And the rules, of course, also do not speak of the manner of examination, the manner of the questions, even though in the world of the actual practice of international commercial arbitration, there is a manner of posing these questions. I just wanted to bring before you these issues because I think that when we get into the rules and we see the nuts and bolts of the IBA rules, and maybe if we have enough time, talk a little bit about the Prague rules, you will see that there are a number of ambiguities in the rules that are somewhat deliberate, that present you with strategic and tactical opportunities in using those rules, not just in the very limited space of oral examination, but in actual evidence taking. And that word, that phrase, evidence taking, that's what we have in ICA, not discovery. We have evidence taking. And that evidence taking, I will share with you, is very, very, very unique and does not really resemble discovery. It only resembles discovery in very broad terms, much like, for example, a canary may resemble an F-35 fighter jet. They both have wings and fly. But beyond that, there's not much that's in common. Although it is not the subject of today's discussion, these observations raise the question of whether beyond the IBA rules and Articles 31 and 32 of the Vienna Convention of the Law of Treaties, there is such a thing as international law evidentiary, as an international law evidentiary regime. Is there a rubric of international law of evidence? That's the meta question that lingers. And I will suggest to you also by way of background that there is no such thing, that it really doesn't exist beyond the two bodies that I've mentioned, the two sets that I've mentioned, the Vienna Convention and the IBA rules, and of course, the Prague rules. Beyond that, I tell you, it is my opinion that there is no such thing as an international law evidentiary regime. And the ICJ, in fact, has shared that there are no international law rules of evidence. And this general context is helpful because it will allow you to contextualize better the deficits, which I would like for you to view as opportunities, that the IBA rules and the Prague rules actually present. Consequently, it is not possible to have conceptual coherence in any form of conversation, let alone a lecture, that purports to discuss discovery in the context of international arbitration, let alone ICA. As a condition preceding to engaging in any taking of evidence effort, one first has to examine what taking consists of, what is taking in this context. Likewise, it is equally necessary to explore what is meant by evidence. Put simply, how do we take and what can be taken? The how and the what, before engaging in that, let me just share with you that the taking of evidence, whatever that may mean, is the second most consequential and important undertaking that you will have in any ICA proceeding. I repeat, it is the second most important decision and set of decisions that you will make in an ICA proceeding. The first has to be, we should travel on this assumption, the first has to be the appointment of that arbitral tribunal, which I dare to share with you may almost be case dispositive. So then, how do I take and what can I possibly aspire to take? The first place to start to try to get an idea of how to take and what can be taken are the rules themselves. Now, very briefly, let me share with you that these rules benefit from about 37 years of experience. The IBA supplementary rules governing the presentation and reception of evidence in international commercial arbitration of May 28, 1983, this is the first iteration of these rules. Please focus on the title. Again, IBA supplementary rules governing the presentation and reception of evidence in international commercial arbitration. The rules purport to govern the presentation, in quotes, the reception, in quotes, of evidence, in quotes, and international commercial arbitration. The title matters, and I will ask you to engage in evidence taking, which will include advocacy in connection with the effort to take evidence, to reflect on titles and the significance of titles. This iteration of the rules seems to suggest that the, quote, presentation and, quote, reception of evidence are two separate and distinct phases. It also suggests that the rules apply to ICA only and not to international arbitration generally, meaning ISDS, international investor-state dispute resolution, investor-state dispute settlement, treaty-based arbitration. The IBA rules, secondly, that's the first iteration. The second, the IBA rules on the taking of evidence in international commercial arbitration, June 1, 1999. You will note that the terms presentation and reception are no longer present. Moreover, that magical and hopefully to your opposing counsel terrifying word, taking, appears for the first time. As a related item, I bring to your attention that in the year 397 BC, Plato wrote a dialogue titled Cratylus. It discusses whether names, including titles, are correct based on convention or because they are related to the nature of the thing or person being named. If the latter, then as you navigate the waters of evidence, keep in mind that the title of the rules itself may be helpful to determining both the how to take and the what can be taken. Third, the IBA rules on the taking of evidence in international arbitration, May 29, 2010. Please observe here again, the title is different. The word, quote, commercial is missing. Therefore, if Plato's protagonist Cratylus argues in the dialogue named after him, and the name is not a convention, but rather relates to the essence of what is named, then we can conclude that the rules apply, of course, as supplementary rules, always subordinate to the arbitral tribunal's rulings on evidence taking and general applicable institutional rules to ICA and ISDS. In fact, I think we must reason in this manner because the rules themselves do not offer any text on this point that at all is helpful. The rules do not tell you that they apply now to both international commercial arbitration and investor-state arbitration. Investor-state arbitration is not mentioned, but there is this change in the title alone. And in fact, when you look at Article 1 of the rules titled the scope of application, does not contain the words, quote, commercial, as in, quote, commercial arbitration, or, quote, investor, quote, investment, as in, quote, investor-state arbitration. Notably, however, the definitions of the rule does mention the name, quote, international arbitration, which, faithful to Cratylus's argument, would include investor-state ISDS arbitration. Now, perhaps the most immediate guide to how to take is in Article 2 of the rules, titled Consultation on Evidentiary Issues. It is here that we find the rule's most significant doctrinal contribution, which is the standard of relevance to the case and material to its outcome. Let's stop there for a second. If there's anything that I want you to take from this conversation we're having, is that there is one standard relevant to the case and material to its outcome. Now, what that standard means really is what we're going to be talking about for the rest of our session here today. The standard helps in that it is a modest step towards having some understanding of how to take, and I guess to some extent, what to take. But the standard itself needs to be fleshed out. We need to be thinking about it. But you as advocates, now you're armed with an extremely important piece of going forward in the world of evidence taking and going forward in the second most consequential act or series of acts that you can possibly undertake in arbitration. Significantly, this standard is mentioned 7 times throughout the rules. Indeed, this language appears and reappears at decision-making junctures throughout the rules. We first find it in Article 2.3a, which reads, the arbitral tribunal is encouraged to identify to the parties, as soon as it considers it to be appropriate, any issues that the arbitral tribunal may regard as relevant to the case and material to its outcome. This subsection of Article 2 may be a facilitator for the crafting of evidentiary terms of reference. Articulating this standard at the consultative phase of the arbitration cannot be underestimated. At minimum, certainly at this very early stage, one is compelled to ask, what can relevant to the case and material to its outcome possibly mean? How does one go about determining relevance? How does one go about determining materiality? We will return to this query in considerable detail once we arrive at the what of the what can be taken. For present purposes, however, what matters most is that the first time arbitration counsel, arbitrators, academics, parties, and the entire universe of stakeholders are provided with a standard that, at least theoretically, aspires to guide both the how and the what, this took place now, here. It's in the rules, so we have that. Within the context of the rules, this very important standard, whatever it can possibly mean, relevant to the case and material to its outcome, appears, as we have seen, in the disclosure section of the rules. But just as importantly, it also appears in Article 3, titled Documents. And because we're pressed for time, of all the different types of evidence that can be taken, I want us to concentrate mostly, actually exclusively, on documents, on documentary evidence as the most practical and immediate form of evidence taking that we can discuss in one initial encounter. And this article is perhaps the centerpiece of evidence taking because it addresses how to craft a request for production, a document demand, while of course underscoring the very important standard relevant to the case and material to its income. I feel compelled to read to you Article 3, paragraph 3, A through B, lowercase, and this is what it says. This is what's contained in there. A request to produce shall contain a description of each requested document sufficient to identify it, and a description in sufficient detail, including subject matter of a narrow, specific requested category of documents that are reasonably believed to exist. In the case of documents maintained in an electronic form, the requesting party may, at the arbitral tribunal discretion, may order that it shall be required to identify specific files, search terms, individuals, or other means of searching for such documents in an efficient and economical manner. B, a statement as to how the documents requested are relevant to the case and material to its outcome. Let's stop there for a second. This reference to a statement is going to be mission critical. That's going to be the fulcrum of your argument, of your basis for requesting the document. Now, here's what's difficult. Just because the document may seem important or necessary to you, that's not enough for the statement. the statement has to be crafted in such a way that it meets the standard. And that according to what we've just read, it has to also be very, very particular. It cannot at all in any way resemble a fishing expedition, even though it is very broad. You'll notice that you can request either documents or categories of documents that are reasonably, you believe reasonably to exist. And let me just share with you that the parameters of reasonableness and reason are extremely wide, because the limits of reason begin with what? The unreasonable. That which does not make sense. So that gives you some latitude. But that latitude will be very far from being able to carry the day in and of itself. And that's why, as part of today's talk, I shared with Professors Childress and Co. What's called in our profession a Redfern schedule, named after one of the authors of the chapter that you've read, chapter 7. And in there, when you look at that Redfern schedule that I shared with you, which is from a real case from very, very able counsel, people I know and respect. That's why I gave you the document. It's also a public record, so we're not breaching any type of confidentiality. You will see that that statement is the foundational basis for doing two things. Trying to argue that the document should be produced, and secondly, anticipating objections from the other side. That's in that Redfern schedule you have. Every single statement on behalf of the claimant focuses on those two items. Now, I will share something with you that you won't read anywhere. And I want you to keep it here. It's a secret. We have to keep it within the confines of the class. There is a third reason for having a compelling and powerful statement. And it's called persuasion, advocacy. What do you mean by that? Well, this is what I mean. You're telling your case, you're explaining your case, you're making your arguments in that statement. So if the unthinkable happens, and it happens 50% of the time when you're asking for a document, and you're denied the document, what have you accomplished? I've accomplished something very important, even though I haven't gotten the document. I told my story. I used the document truthfully, reasonably, and within the parameters of the rules to argue my case. And to argue my case substantively, thematically, as to liability, and as to damages. So even in losing, I'm winning. And all that the rule says is that, A, the reasonableness, that you reasonably believe the document or category of documents to be relevant or to exist, in terms of if it's just a document, and the standard. That's all you're doing. So you can see that there's great value in understanding the standard, the parameters of the standard, and using it affirmatively as a form of advocacy beyond just substantiating the standard, anticipating defenses to production. You use it to present your case. Now that's a secret. You can only deploy this, but you can't tell other people where you heard it or where it came from. Now, the relevant to the case and material to its outcome standard, of course, constitutes the guidepost of the obligatory statement that a requesting party must include in the request for production, i.e. in the document demand. A statement, in turn, may either elicit objections from the adverse party or even the arbitral tribunal on either insufficiency as to relevance or materiality, even though that tribunal doesn't know what relevance means. The different members have a different idea of what relevance means. You yourself don't know what relevance means. And materiality, same thing. The tribunal, you have three members. Let's assume you have a full panel because it's a big, important case. And these are the only cases that we really are preparing you to handle the best. They don't know, all three members of the tribunal have a different understanding of materiality, to the extent they even understand the term or purport to understand it. Your opposing counsel has a completely different idea of what it means, and everyone on your team has a different idea of what it means. And soon we'll see that the rules deliberately don't define the terms. So now you have learned that the standard is dispositive, that the how means crafting a request for production based on relevant to the case and material to the outcome. You have also learned that both disclosability, remember we talked a little briefly about Article 2, disclosability and admissibility of evidence within the construct of the rules is governed by the same standard. Let me unpack that so that it's very clear to you what I'm talking about, which is very, depending on where you come from, what part of the world you come from, what judicial tradition you're familiar with, and this is very important. You see, disclosability in our system, in the common law system, I should say, disclosability in the common law system, the judicial system, and the presentation of evidence are two separate and distinct things. And we'll look at that in great detail because that's very important. But in the civil law, in the other half of the world, disclosability and presentation are one and the same thing. Let me be more, try to be a little bit more specific. In the IBA rules require the arbitral tribunal to do four things with respect to evidence. Rule on admissibility, relevance, materiality, and weight. The first three of those four elements, admissibility, materiality, relevance, those three are ruled upon once that Redfern schedule is adjudicated. Once that Redfern schedule is propounded, argued, the other side presents its case, the tribunal then looks at the arguments and reasons and provides a document by document, category by category adjudication. Granted, denied, granted in part, denied in part, and explains what you can have, what you can't have, and maybe some reasons for that. Once the tribunal does that, in an ICA setting, ladies and gentlemen, friends and family, that document has been admitted. It's in. It's been admitted. The only thing that has not occurred is weight. We don't know what weight will be accorded to that document. And that weight can go from 0, which is tantamount to inadmissibility, but it's already been admitted, or dispositive. The tribunal can say, yes, this conclusively proves the matter asserted. But that is a unique feature of what we're talking about in terms of evidence taking in international arbitration. It's very, very different. Very, very different from discovery. Very, very different. And as you're also seeing, it is fraught with tremendous opportunities for advocacy. Now, I want to stop here also for a second and ask you to reflect on two basic issues. The first of these issues is, how do I go about knowing what documents and what category of documents I need? So you walk into the law firm, you're part of the arbitration team, and, a young supervising partner says, okay, I need you to prepare a document demand under Article 3 of the IBA rules. You know our case, you worked on the request for arbitration. You've seen their statement of the case, their answers, their defenses. We need to start developing the record. And you say, okay, I know that it's Article 3. I remember that strange person from Miami talking about that, but since then I've read the article and commentary on it, and I know I know it's working somewhat. But what do I say? How do I start? And, when you first start, it can be a little bit daunting. You have no framework on how to start. What documents how do I go about identifying documents or categories of documents? This question, of course, is a very legitimate one. Indeed, many seasoned practitioners are clueless as to how to approach the beginning of the beginning, or as Aristotle writes in his Posterior Analytics, how do we arrive at first principles? Consider this approach that I'll share with you. This also has to stay in the class. Please don't go out, don't give away these pearls I'm sharing with you. Don't give them to the others. Don't keep them yourself. Assuming you are a claimant, the following 6 conceptual categories that are conditions preceding to the identification of individual documents and categories of documents would be a necessary exercise. So consider, without limitation, an approach where you sit down and you're saying, okay, now I'm going to put together in Article 3, a request for production, a reference schedule. Let me see how I'll go about it. First, you will need documents that meet the elements of your foundational claim. For example, if you have a claim for fraud or breach of contract, in any applicable law, whether it's the French law or the law of the state of New York in the United States, you look at the elements of your claim and you break down those elements and you start thinking about the types of documents or categories of documents that you would need to establish, to prove, to show, to demonstrate concretely that claim. Second, I want you to think about impeachment documents. This category would seek documents that, as closely as possible, either directly or pursuant to reasonable inference, would provide the tribunal with a factual predicate from which it may or may not infer that respondent knowingly or through reckless carelessness, for example, is misrepresenting a relevant fact. Depending on your claims, you will note that I limited the standard to one of relevance and omitted deliberately any analysis of materiality in this impeachment. And I will explain more on the relationship between relevance and materiality later. But what you want with impeachment is not necessarily to show that a cause of action, that a claim can be established as a matter of evidential proof. No, what you want to show is that there's an inaccuracy that is so great that it's either intentional or just completely reckless, irresponsible. This is an attack on credibility. So you want documents that will impeach, that will attack the credibility of statements already made in respondents' written defense to the case. Third, you want documents or categories of documents that will help you develop the theme of your case. Yes, theme of your case. What does this mean? This means that your case will have, and you will, as an advocate, as a proponent of claims, you will characterize your entire case in 2 to 3 phrases that will resonate with the arbitral tribunal without being trite, and that will summarize for the arbitral tribunal 1 or 2 or maybe 3 at the most important approaches to the merits that you are suggesting over and over again through your documents, through your document request, through the statement in the document request, through your witnesses at the final hearing, in every argument, at every opportunity, at every hearing, in every submission, where you can do so, of course, coherently and without offending the tribunal or making a fool of yourself. You will also have document categories that will establish damages. A lot of times, even very experienced lawyers forget that they need to develop damages beyond just within the confines of expert testimony. You want to develop damages from the other side to the extent possible. And you want to, at that point, you will craft this series of requests that go to the issue of damages, hopefully with the counsel of your expert, whom you will hire before you file the case, presumably, because you want to learn what kind of a case you have. And damages typically is the last element of any cause of action. But moreover, you have to know the value of your case. You have to know, and you have to advise your client the extent to which this is even something that is viable from an economic perspective to bring. What's at stake? What's the value of your case? So you want to use the Article 3 demand to also elicit elements of your document, of your damages position to the extent possible. But here again, just think about it. This is a wonderful opportunity to let the tribunal know what? How you've been hurt and the extent to which you've been hurt. What this is really about, why you're here, what you seek, what you need to be made whole. So you're arguing the merits of your case. Even if you lose and don't get the documents you're asking for, so long as you're following the rules, you're being reasonable and you're adhering to reasonable, relevant to the case and material to its outcome, to that standard, as you understand that standard, as you can defend that standard, then this is something that is extremely important to do, and that very, very, very few people do it, and even fewer are able to do it successfully. You want documents pertaining to party and non-party witnesses. And you also want documents or document categories relating to anticipated defenses and to anticipated affirmative defenses. Of course, this list is hardly exhaustive. The pedagogical point here is to underscore that the approach to evidence taking requires strategic thinking even before engaging in the tactical execution of drafting a document demand. The how begins with having a profound understanding of your case and the manner in which you will present that case beyond just considerations of general categories of liability and damages. The relevant to the case and material to its outcome standard constitutes more than just the subject matter of the obligatory statement that a requesting party must include in a request. As you have seen from the reference schedule that I shared with you, that statement explaining relevance and materiality in the context of document or document categories at issue may either elicit objections from the adverse party or even the tribunal itself, or on either insufficiency or lack of particularity. So these are also categories that you want to be thinking about. Now, as part of this first point concerning a statement in the request for production that amplifies the relevance or materiality of the evidence sought, I want you to consider what is actually taking place. I want you to understand that what you're actually doing is arguing with the tribunal or for the tribunal and against the other side. So I want you to always be thinking about that and not just presenting a unilateral declaration that doesn't take into account these other factors. Now, here's something that I wanted to bring to your attention. In very sharp contrast to discovery, which is a separate and distinct from the presentation and admissibility of evidence, in ICA and under the IBA rules, the same standard as we discussed before governs both evidence taking, disclosure requirements, and the presentation and admissibility of evidence. And we've already discussed that, and I want you to always keep that in mind, that the only thing that will remain pending for that final hearing will be the weight. And for that, we can have a separate class one day. The same standard phenomenon is a product of this phenomenon of having the same standard apply to both presentation and taking of evidence is a product of a hybrid approach that tries to reconcile common law and civil law judicial cultures in the way that we discussed. In the United States, let me just tell you what pretrial discovery disclosure is like, just so that you understand. Now, keep in mind, in ICA, you have relevant to the case and material to its outcome, right? And we said that if it's relevant to the case and material to its outcome, it's already admitted. And we also said that the only thing that's pending is the weight to be accorded. And we also said that it could be that at the final hearing, you argue the other side argues so successfully in opposition to the evidence that you're facing and presenting and discussing at that point, that the tribunal may accord zero weight to the evidence, which would be tantamount to inadmissibility. That's where we stand, okay? Now we're saying, what then? How does that contrast with discovery? Discovery is part of a fragmented proceeding, as we said before. Now look at this. This is the discovery equivalent to relevant to the case and material to its outcome. I want you to hear it. I want you to know it, because you're going to understand something very, very basic. It's going to underscore what we've been saying about presentation and only weight being pending. Listen to this. This is what this thing says. So I'm reading from what it actually says. It says, unless otherwise limited by court order, forget about that. The scope of discovery is as follows. Parties may obtain discovery regarding any non-privileged matter that is relevant. First time we come across an explosive word, relevant to any party's claim or defense and proportional to the needs of the case, considering the importance of the issues at stake, number one, in the action, the amount in controversy, $10, $10 million, $10 billion, the party's relative access to relevant information, the party's resources, a pro se plaintiff, the importance of the discovery in resolving the issues, mission critical, without it we can't resolve the issues, and whether the burden or expense of the proposed discovery outweighs its likely benefit. That's neither here nor there, but it's interesting. It's always an argument to make. Now, here's what I really want you to hear. This is what I really want you to understand. The last sentence, it says, information within the scope of discovery need not be admissible in evidence to be discoverable. I'm going to repeat it. Information within this scope of discovery need not be admissible in evidence to be discoverable. So you can have, in the common law system in the United States of America, you can seek, you're entitled to documents that themselves, the pair of glasses, the document, the thing itself is inadmissible. It's inadmissible evidence, but here, you can have it. In fact, you're entitled to have it. It shows you the bifurcation that is not present in ICA and the scope of discovery. And discovery is relevant, notwithstanding the comment in page 8 of the chapter 7 that you've read, that basically says that under the ZF Automotive, basically 1782 is more or less irrelevant in the context of international arbitration. I disagree. I will give you a different version on that in just a second. So the discovery, understanding what discovery is, remains critically important still in international arbitration, and certainly in a 1782 context. And there is one rule under the ICDR rules that under certain circumstances would allow parties to use depositions as an instrument. I assume that if you're going to use a deposition, the standard will be the standard that's used in a deposition, which is the standard that I just shared with you. Now, the predecessor just held that the discoverable evidence merely had to, what I just read here, that the predecessor to this rule merely said that the discovery, that the standard for discovery was reasonably calculated to lead to a discovery of admissible evidence, reasonably calculated to lead to a discovery of admissible evidence. That's what it was before. And again, if it's reasonably calculated to lead to the discovery of admissible evidence, also by definition, that evidence itself need not be admissible. It can be inadmissible evidence, so long as it's reasonably. And we already said that whenever you come across the word reasonable, that's a big red flag. We're moving, we're taking on a lot of time here. I want to get to something that I think will be helpful to you. And so I'm going to skip forward, and I'm going to talk to you a little bit about this situation we have with the rules, where, the rules don't define evidence, the rules don't define materiality, the rules don't define relevance, the rules do not define best efforts, the rules do not define good faith, and yet the term good faith bookends the rules. It's in the preamble and again in Article 9 at the very end. So none of these terms are defined. And I said that they're not defined by design. They're not defined. If you were to define them, then what would happen? You would be subscribing to one particular culture, perhaps, juridical culture I'm talking about. And that would be maybe somewhat problematic. Here's what I want to start closing with. So I want to share with you one approach to trying to find the meaning for relevance and materiality. And again, I propose the U.S. Federal Rules of Evidence because of their inherent merit and not as a factor favoring the Americanization of international arbitration. Under Rule 401, the test for relevant evidence provides as follows. And this is what it says here, okay? I'm reading it to you. Evidence is relevant if A, it has any tendency to make a fact more or less probable than it would be without the evidence, and B, the fact is of consequence in determining the action. The fact is of consequence in determining the action. Now, let me just explain very briefly what this means. This is how I'd like for you to break it up. I want you to argue in the statement that document X or category of documents X will have a tendency to make a fact more probable than not having that document. In other words, you want to say that an ultimate fact in an element perhaps of your claim can be established and will be more probable, it's more likely if in fact the tribunal considers this evidence and allows for this evidence to be produced and form part of the case. In effect, admits this evidence. And then later we can fight about what it means. And now notice that the rule that I'm citing to has B, the fact is of consequence in determining the action. The first part of this rule, I will talk to you about this right now in closing. The first part of the test A has three operational elements on which to structure the initial qualitative analysis to determine relevance. First, the term any tendency requires an initial determination on the degree propensity of testing. Any qualification, the word any as a qualification itself will lead to an assessment that is qualitative. Second, to make a fact more or less probable, that will give you an abundance of resources to work with. And third and finally, as to the first part, then it would be without the evidence. The test for relevance necessarily requires examining different inferences as to a particular proposition with or without the evidence of concern. So you will craft all sorts of arguments, hypotheticals, what would it mean not to have the evidence? Okay, and then finally, just something on the meaning of materiality. The meaning of material under subsection B provides for what is in effect a materiality consideration, but phrased in a manner that is universally more accessible than the term of art. So what has happened is that the word materiality was taken out of the rules, and instead this test that I've just read to you in B is what is in its place. This language, the fact is of consequence in determining the action, is what is ultimately extremely, extremely important. What you want to argue to that tribunal is that without this fact, we really can't adjudicate. We really can't determine the merits. Without having these documents, you will be foreclosed from really determining the merits in some essential way. That means that the term materiality necessarily includes relevance. Materiality necessarily includes relevance because it's really outcome determinative. It's necessary to determine the outcome. It's a condition preceding. So something can be relevant but not be material. The paper of the contract is Egyptian papyrus. It's relevant. It goes to the contract, but it's not material to the terms of the contract. It doesn't work. So what are you ultimately doing? What are we ultimately talking about? We're trying to talk about providing the terms relevance and materiality with an objective meaning and not a subjective meaning. The subjective meaning is the meaning that's accorded under what I call, or what is the literature calls, the free proof approach to evidence, which is the civil law approach to evidence, which is not based on strict rules, or let alone strict rules that have exclusionary evidential rules. It's just based on what's called condition intime, your gut feeling, your intuition, what your gut tells you about the assessment of the evidence. And what I'm suggesting to you is that you should try an approach that yanks away from the tribunal that type of discretion and tries to objectify the actual test, so you can propose the better and most important arguments in favor of your position. And I would like to close by just sharing with you that, much like Shakespearean beauty in ICA, both relevance and materiality are, quote, in the eye of the beholder, close quote, an alternative dispute resolution methodology promising efficiency deserves more than just a subjective ad hoc approach to precepts so central to epistemic evidentiary analysis as relevance and materiality. Objective certainty, or certainly an aspiration to objectivity, certainty is not just welcomed, certainty is actually necessary. And with that, I want to thank you for your patience in hearing me out.
Let's begin by saying, wow,
Yeah.
that was a master class, and well beyond what we had even hoped for. And so let me just say thank you, Pedro, for that overview and that deep dive. And I learned a heck of a lot, and I know everyone in the room learned a heck of a lot. And Jack learned a heck of a lot. And if Jack learns a heck of a lot, then we're in for a good afternoon.
I really did. Thanks, Pedro.
You're such a liar, but that's okay. Listen, it was a privilege, guys. And so if you have any questions, if you want to talk about this, please feel free to send me an email. You can look me up online, and I'll be more than happy to address anything. So having said that.
Thanks, Pedro. You have time to take a couple questions now?
Sure. Yes, of course. Yes.
Excellent. So I'm sure folks will have some, but let me see if Jack wants to lead off with any observations or questions.
Yeah. What is there a demonstrable difference between tribunal that says they're going to be inspired by the IBA rules in their procedural order because the parties did not actually stipulate those in the contract. Versus saying outright, we're going to apply them. In other words, the very precise use of language that you engaged in certainly makes sense when the parties have incorporated that into their contract. But sometimes you get, this cut and paste kind of thing. The tribunal will say, we're going to be influenced by the IBA rules, especially articles, 3 and 4, or whatever it happens to be. Does that change the approach?
I think that it changes the approach to, yeah, I think that mentioning the rules in the in the arbitration agreement, it changes one aspect of the approach. I mean, here's what I really think. I think that if you mention the rules, the tribunal will ultimately, the tribunal is not going to incorporate the rules to the exclusion of its own judgment. But the tribunal will view the rules as what the rules purport to be, supplementary guidance, so that you have, first the mandatory rules, whatever the arbitral tribunal believes, and then the institutional rules. Now, the institutional rules, I have here the ICC, but we just don't have time. And the ICCs, in the ICC, for example, I don't think the word evidence even appears. So there's really, what happens ultimately is this. You say the parties stipulate to the use of the IBA rules of the taking of evidence in this proceeding. And the tribunal, even if you say you stipulate to that or agree to the use of the rules, the tribunal usually just says, as you know, Professor, just says, well, we'll look at the rules for guidance. We'll look to the rules for, reference, but, we're not going to be bound by the rules. But now you've done something great. Even if you get that far with the tribunal, which is usually how far you get, you've now brought objectivity into play. And all of international arbitration, all of international commercial arbitration is about influencing the tension between party autonomy and arbitrator discretion. You want to take that arbitrator discretion as far from the arbitrators as you can and whenever you can.
Pedro, I'll turn it over to students in a second. I had a question. For those trained in the common law, and in particular under the federal rules, it seems quite surprising that the person seeking the discovery has to make an affirmative statement to the tribunal as to why it is relevant and material. And I know you said multiple times that this is a point for advocacy, that this is the ability, that this gives the ability to the person who's seeking the information to advocate to the tribunal. It also seems to me, though, that it runs the risk that you give away some of your theories of the case or some of your framing of the case that you might not want to tip the other side off to, at least fully. And again, I wondered if you could say something about this difference that you've seen between discovery in the context of the federal rules, where you just requested and it's up to the other side to object and say not relevant, privileged, versus the IBA rules, which require the person seeking the information to come forward and say why they need it.
Yeah, I've heard that before, but once you think, and by that I mean the proposition that, gee, you're giving away secrets, you're giving away things that are important in the case. It's hard in practice to really come across situations where you say, no, I'm not going to let them see what the guns look like because I don't want to show them the power or the force or the normativity behind these arguments until later on. Usually, I think what's best is to raise these arguments as early as possible and to show your dry powder as early as possible. I think that's what really moves the needle in terms of getting strategic advantages, both with the tribunal and even heightening the possibilities for risk assessment and settlement, which is a big pet peeve of mine. But no, I don't really think that you run that risk.
And one just follow up, you noted the bifurcation that exists between relevance and admissibility. again, comparing the federal rules, where something can be relevant and proportional, even though it's going to eventually be deemed inadmissible. I thought it'd be interesting to hear you reflect just a bit more about the fact that once that relevant and material determination is made before a tribunal, necessarily means that the information's been admitted, but it may not be given the weight that the party is hoping for. What do you, is that a benefit that the determination of relevance necessarily leads to admissible evidence, or does it become a distraction or a risk that the tribunal is receiving too much information that may be swaying them one way or another?
I think the latter. I really do. I really think the latter. I think that what actually happens with this, the mechanics, the workings of this rule in practice, is that the tribunal really is overwhelmed, I think, with a lot of information at different stages. And I really would prefer to have a system that differentiates a little bit more between what parties are entitled to have, rather than just have it all, have admissibility and disclosability treated as one. I mean, you have to understand, in a civil law context, when you go out and you try a trial in a civil law jurisdiction, I've tried many. In Spain, I'm licensed there, and I've had many cases there. When a complaint is filed, that day, that instance, the trial starts. You're in trial. And that's what's happening in arbitration, but people don't really realize it. Sometimes not even the arbitral tribunal realizes it. But once you start with that reference schedule, you're already overwhelming that tribunal with evidence and argument and evidence and argument and evidence and argument. And, depending on what Professor Cole, I know, has a lot of experience as an arbitrator. Different arbitrators treat it differently. I mean, but from that very point in time, I think there's a consciousness about what's going on here that starts to develop in the minds of the arbitrators, because they're already dealing with evidence in the case.
One follow-up question has to do with due process, paranoia, and paralysis.
Yeah.
In responding to the reference schedule, how do you give courage to the tribunal to say no to requests that, as you say, will end up just being a flood?
Due process paranoia doesn't exist. Okay. That does not exist. It is the silliest thing in the world, because in international arbitration, we all know that due process means something very, very different than it does in most countries, in most judicial systems. In international commercial arbitration, we have attenuated due process. We have a due process that is significantly easier to meet than the due process that we have in judicial proceedings. That's why in international arbitration, the tribunal has absolute discretion to reject relevant and material evidence without any punitive consequence. Practically speaking. And that's one of the concessions that practitioners, or not practitioners, that stakeholders, that parties make when they allow for international arbitration, and they go for international arbitration instead of a judicial proceeding. You know that you're sacrificing your due process rights at the altar of efficiency and expediency. And Professor Coe knows this inside out from the restatement of instances, dozens and dozens, and you know it too, Professor Childress, obviously, but I'm just thinking about, I'm sure that in the restatement and process, Professor Coe went through, there's such a plethora of cases where arbitral tribunals, it's within the arbitral tribunal to reject admissible evidence, and to just simply not allow it. And unless, it's of a very, very particular kind and extremely consequential, nothing's going to really come out of that.
And I know you said it was the subject of another session with us, weight.
Yes.
I know I should invite you back, and I want you back for another hour on the weight, but can you just
Next week?
Yeah, can you just give us some clues about the parameters? Obviously, either you're attacking the weight or you're trying to fortify it in the eyes of the tribunal. What's involved in that? Because disability is maybe, liberal, but the weight is where it's at.
Yeah, the weight is where it's at. And again, let's just go back. I think to approach the issue of weight with seriousness, to be adults discussing weight, we have to talk about what the ICJ says about evidence in international arbitration, because no one else seems to say anything about it on this issue, on the issue of the importance of evidence. And obviously, what we find in the ICJ is contextualized by VCLT 31 and 32, but we can see some things that guide us and that I think apply directly to ICA. One of them is the quality of the evidence. What are the particulars of that evidence? What does that evidence actually show? In what context was the evidence generated? What is the history of the evidence? Who authored the evidence? The purposes, the provenance of the evidence, not in terms of chain of custody, but in terms of chain of functions that it had over time. So a qualitative analysis of the evidence, obviously within a relevance and materiality framework, that's what matters. That's the weight. That's where the conversation about weight starts. So, the weight elicits from you the whole comprehensive universe of evidential arguments where you, of course, go through, there's relevance and there's relevance, the parchment paper on the contract versus, the intent behind the particular clause, evidence that shows that intent in the way of admissions, perhaps conduct, and then the materiality, how that, without that, you can't really even aspire to be in a position to adjudicate the issue of liability being presented, contractual liability being argued here. And then after that, you start with the qualitative analysis of that evidence. And again, I think there, regrettably, very few people do it, but we do it. We do it all the time in all our papers. I do it. I go through all of the ICJ type of analyses to try to persuade that tribunal that this evidence is of the highest quality and should be given the most, dispositive weight where possible. But I always start by telling that tribunal that technically this may have zero weight, but here's why I believe it not only has a great deal of weight, it's dispositive. But you're right, this is an entire semester talking about weight, because weight is the entire game. But most people don't even know this ICJ authority exists.
I have at least one student that's been very patient, his hand up. Pass the baton here in a moment.
Yeah, you may not need the mic, just try the question without the mic first.
Oh,
Yeah, Mike.
I have a question. You mentioned when you were formulating damages that the relationship that you have with an expert predates even like the submission of any documents. That spoke to me that it's a much more collaborative relationship than you would otherwise find in like a US court, and I wondered if you could speak on how you identify those experts, to what extent can you like work with them without them actually, they're not an attorney and they're not an advocate, but they have a deep influence on the case. I was just wondering if you could expand upon that a little.
I'm sorry, the last two sentences you were breaking up. It
Oh.
sounded like you were underwater.
Sorry, is this better? I was wondering, if you could expand upon the relationship that you talked about, with experts in international commercial arbitration sense, because it seems to be a much more collaborative, relationship in terms of formulating damages, and document submission. Like you said, it predates the submission of any damage documents, so it's not just testamentary evidence. They actually have a role in drafting, and I was just wondering what that looks like.
Yeah, Pedro, maybe you could, I think you were saying in the context certainly of quantum, you will reference the experts to figure out what documents you might need.
Yes, yes.
But could you say a little bit more about that? And also, to the extent, if at all, you use experts in non-quantum phases to help you develop cases, and then how you keep those conversations, from not being subject to some general discovery otherwise.
Yes. Well, first of all, yes, we use experts. We certainly use experts, both as to liability and quantum, before we file a case, because we want to understand what our case looks like, and we want to present the most powerful case. And we do this before we file a case. This is a question of style. The client hires the expert, and directly or through the firm, but it's very clear that we want the client involved so that it's a privileged communication that really cannot be discovered. So if you have a retainer agreement with an expert, for example, you don't want that to be discovered, and you don't want that to be disclosable. Usually the scope of an expert's opinion, that sometimes goes through several iterations in writing with the expert, and refinement. You don't want that to be, obviously disclosable. And so basically what we try to do is to make sure that it all falls within, work product doctrine, and also it's part of the attorney-client privilege. So that usually will not be a problem. And arbitral tribunals really shy away and actually are fairly decent and hard on those lawyers who try to get that type of strategic advantage in the arbitration by asking for drafts or asking for a retainer agreement or all communications between you and Miss or Mr. Expert. But what is important, I think, and what I would try to share with law students and LLM students who are lawyers, but trying to get different perspectives on the practice of law, is to always retain the experts before you have the case. Try before you file the case. Learn your case. Don't learn your case as the tribunal learns the case. Don't improvise. You should have all your experts lined up long before you file that request for arbitration.
And I guess we should differentiate between consulting experts, which is what you've been describing, and testifying experts. Because obviously experts that would go to testify before the tribunal, there would be much more of an ability for the other side to question conversations, to question drafts, to question preparation and other things.
Yes, absolutely. But you'll be, even there you can, certainly, it depends on the tribunal. Again, this is part of what we have here, is that we have very limited evidentiary bodies, evidentiary rules that would apply. It depends really, Professor Childress, if you think about it, on how that tribunal's particular disposition on that issue. for example, assume you're cross-examining an expert, and you're in that cross-examination of the expert, you say to the expert, you prepared your expert report, right? And the expert says, yes, but before you prepared this expert report, you prepared other reports. Yes, in fact, you prepared what, 4 or 5 reports? And the expert says three reports. Okay, let's start talking about the first report you prepared, sir, right? The first report is different from this report, right? Yes. And when you prepared that first report, when you finished preparing it, you said that to counsel, didn't you? Yes, I did. And you got it back from counsel? Yes. And it had notations? Yes. Now, I'm not going to ask you what notations, but that report changed, didn't it? Yes, it did change. And you haven't provided that draft here. Well, no, I didn't provide it because you never asked me for it. But you didn't provide it. Is that part of this record? No. Okay. Then and then you go like that right through the 3 iterations. Now you're already creating a sort of impeachment type thing. There are arbitral tribunals that will let you develop all that. Others will not. Others will say that's not relevant to the case and dispositive to helpful to the outcome. It doesn't meet the standard. It doesn't really. It doesn't. It's not there. It's not relevant. It's not material. Pick another line of ask him about the report or ask her about the report. This is not material to the outcome. If you're trying to say that the expert was influenced by counsel, if that's what you're trying to prove, this tribunal's not interested in that. Move on. So yeah, I mean,
Okay, can you hear me all right? Is this better? Can you hear me all right?
hello? Sorry?
Is this working?
Yeah.
Can you hear my question? I can,
Maybe speak up.
Or ask it and I'll repeat it.
okay.
Jack, is mic on?
It's on? Yeah, it's on.
Yeah, I turned it on.
All right, well, I'll do both.
Sarah will ask the question and then I'll repeat it if you can't hear it.
Okay.
Okay.
I think my question is about, like, in the sense of talking about advocacy and like each step and like exploiting the deficiency in rules and like different places where I think, like you're, just inserting advocacy in each of the places, of describing like what you're asking for. Because of the element of party autonomy in arbitration, is there a point where a tribunal might look less favorably on counsel that is kind of like over advocating? And like, it just seems like when we started our introduction of the theory class that there's so much emphasis on party autonomy and you're choosing to be there as opposed to a court that you've been dragged into. And so I was just wondering like if a tribunal would hit a point of like starting to dislike that in an advocate.
So Pedro, you pointed out, always take the opportunity to advocate all through this process, Redfern schedules in particular. And Sarah's wondering, what's the risk of over advocacy? And at what point does a tribunal sort of say, get real here? I just want to know the basics of why this is relevant to the claim or defense. And is there a risk that you can turn the tribunal off by this constant focus on advocacy? In other words, where's the line? How do you make sure you don't cross the line?
Yes, thank you. I think that's an excellent question, and there is no one answer. First, you have to understand who is your tribunal. You have to understand those men and women, or women and men, who are the people there? How do they think? What you know about them? That's the first thing. You have to know your audience. But let's assume that we do not know our audience. The best way to avoid being intemperate, I would say, and abusive in advocacy is by engaging in what I call explanatory advocacy. An advocacy that just purports to explain, A, your approach to relevance. What is your definition of relevance? And you tell the tribunal this is relevant. For example, this is relevance, and then you use the, let's assume the 401A prong. And you define materiality, and you also use that. And you argue always within a frame of objectivity where you're explaining and not forcefully arguing as you would, understand that term of argument. The force of logic and the force of objectivity should be your normative points in the advocacy. And I think that if you manage that, you're never going to get to a position where you're over arguing. But I will tell you that, so you argue in ways that render the conclusion a necessity by explaining your premises very clearly. So this is an art. It's not a science. You need to understand what that tribunal is. Who are these people? What is their pain level? And then also engage in an explanatory argument, always type of argument where you're the voice of reason. That's why at one point I said that one of the things that I personally try to do is in explaining weight and discussing weight is to be very upfront with the tribunal and say, the weight to be accorded to this item can go from no weight to some weight to even being dispositive for a proposition asserted. And not every evidence, every piece of evidence that you're arguing should be dispositive. Some of it isn't at all. It's just impeachment or thematic. I believe in being open and sincere with the tribunal. And when the tribunal sees you as a voice of reason, as someone who is always arguing within a framework that is outside of sheer subjectivity, you will find many good things will happen to you. And you'll never be over-argued. You'll find situations where the tribunal will say, well, is there authority for that proposition? And you'll be shocked because they'll even all three of them will turn to you and see if you have an opinion on the matter. So it's all a question of how you present things and who you're talking to.
Pedro, I think that TC Energy Redfern schedule you sent demonstrates this. You read the explanations and it seems like they're just the facts. It seems so reasonable, so clear, but there's advocacy going on there. But it's not written with lots of adverbs. It's, as you said, here's my premise, major premise, minor premise, here's why I need it, here's the conclusion. It's advocating, but it's not selling in a way.
Yeah, that TC Energy, that is this is the best piece of work, I think, in that entire TC Energy case. My case now, the case I was talking about very earlier, is tries to reach a result different from what the tribunal and TC Energy reached.
Well, we'll be thinking of you this week. Other questions? Yes.
Maybe I can just ask it and you repeat it.
I'll try that, Mike. Let's see.
Hello, thank you for your thoughts that you're here. I wanted to know whether this whole process is about finding the truth or like only like kind of a game who does better in presenting their truth. Makes sense.
The question, in case you didn't hear it, is how much is this really about the truth and finding the truth versus, a cat and mouse game?
Well, yeah, thank you. That's an excellent question. I don't think it's ever a cat and mouse game, to be honest with you, because I don't think that in many of these disputed issues, there is an overriding universal truth. The TC Energy case, for example, is a perfect example. That case at the jurisdictional level has to do with an interpretive provision in an annex. And it just has to do whether that annex covers a particular series of acts over a particular series of for a particular time frame, or does it not? You could say, well, look, the truth is X or Y. And it's such, that is the truth, because there are these documents that prove this proposition, while there are no documents that prove this other proposition. So therefore, that must be the truth. But even underlying that assessment is the untested assumption that evidence is probative of truth rather than of particular propositions. So I don't think this is ever a question of truth versus a cat and mouse game. I do think, however, that advocacy is about the appearances that you can generate, the phenomenon that you can generate before three spectators call the tribunal.
I have a question. Yes.
Thank you so much, Professor. My question was regarding the weight yet again. So is that the weight of the evidence, is that looked through, or is it speculative measure of how tribunal would look at it? Or the other party, or is it my truth? Or like, peers at it?
Professor, can you repeat the question?
Give it one more time.
Sure. So I'll repeat the question. What I wanted to ask you is, whose perspective are we looking at the weight of that evidence? Because you said the evidence is kind of like functionality, right? Who would be speculating as far as the weight goes of the evidence?
Whose perspective? Wait, yeah.
What's that, Professor Childress?
He's asking whose perspective do we look at the question of weight from? Is it, are we looking at it, is it the perspective of the arbitrator, or is it some other perspective? Where do you get, is it a subjective perspective or an objective perspective, and where does the perspective come from?
Yeah, the perspective you always want in evidentiary tenders is an objective perspective that cannot be reasonably opposed, where it would be unreasonable to take a different position. And you want the tribunal to assume that objective perspective. Now, that's very difficult because it's very difficult generally to persuade anyone to be objective, because we tend to be extremely subjective. We're all subjects, and we're all limited physically and mentally by a very particular point of view. So that's always very difficult, but that difficulty is compounded and made worse when that tribunal is comprised of practitioners who have been, or theoreticians who have been trained in a system that says you evaluate evidence not objectively, but based on your intuition, your particular feel, your gut instinct for the quality of that evidence within the context of the case that has been presented.
Who's more objective, Professor Coe or Professor Silverman?
Nice try.
I'll take the fifth on that.
Any other questions? Well, it's 5 o'clock somewhere and it's almost 5 o'clock in Miami. Are you getting steak for dinner tonight? What's on the menu?
I'm sorry, what?
What's on the menu for dinner tonight?
I think Mexican.
Ah, very nice. Well,
Yes,
I
I think fajitas and Mexican Coca-Cola, that is.
Be careful. Be careful. Well, let's put our hands together one more time.
Anyway, well, thank you. Thank you for having me, and thank you for being so kind and so patient.
Well, thanks for being so generous with your time and with your knowledge. So many kernels of wisdom that I think we'll keep as secrets. We won't turn to the other side, but we'll certainly take away with us. We look forward to seeing you soon. And unfortunately, you're so good. We're definitely having you back, Pedro.
Thank you, professors. Thank you.
We'll be in touch. Great to see you. See you soon.
Goodbye, guys.
Have a great weekend.